Professor Morley, what are the most critical problems that you see raised by defendant-oriented nationwide injunctions?
Most basically, there's strong Article 3 problems. There's a question as to whether a plaintiff has standing to ask a court to invalidate a law or to enjoin a law for third-party non-litigants. Right? A plaintiff typically has standing only to enforce its own rights, only to assert its own rights. And so under the court's standing doctrine, there's a strong argument, in my view, that the plaintiff doesn't have standing and a court accordingly doesn't have jurisdiction to grant relief that's unnecessary to redress the harm to that plaintiff that's tailored for the benefit of third-party non-litigants. As I had mentioned before, we already have a mechanism. If a plaintiff wants to enforce the rights of third parties, to bring them before the court through the class action device, and in particular, Rule 23b2 was adopted specifically to allow civil rights class actions in order to enforce the rights of the broad classes of people. And most basically, they're contrary to the structure, the way that Congress has chosen to structure the federal judicial system. Under the Everts Act of 1891, Congress chose to create separate circuits with distinct bodies of law. If Congress wanted the first judge to rule on an issue to give that opinion the force of law throughout the nation, Congress could have structured the judiciary that way, but it chose not to.
I want to thank the witnesses and yield back.
Thank you.